Hello and welcome to today's edition of Nation Watch. We are a bit late today. We apologize for that due to some difficulties here. It's Sunday, 6th April 2025, and Nation Watch comes to you today as we get closer and closer to the election year. We'll be discussing some very, very important issues pertaining to elections 2025. But before we get there, there are a few issues I like to bring to your attention. Last Sunday, we discussed what's happening in Mabaruma, and there was a weak attempt at denying the report that Nation Watch brought last Sunday with respect to what was happening in Mabaruma, allegations of the discovery of what is believed to be a forged Guyana birth certificate in the hands of a foreign national in the Mabaruma sub-region of the Barima-Waini region. And we reported that that discovery caused the police to become involved, and an employee of the regional administration was questioned. Having been deemed important in the course of that investigation, a house was searched. We made the point that the employee was part of a group operating in the regional administrative office under the direct supervision of the regional chairman. We also reported that the person who at the time was of interest to the police is in a relationship with a senior administrative officer of the region. I'll tell you, it's the regional executive officer. And we made the point that we do not expect anything much to come of the issue. I noted that one particular newscast, not credible enough by my own estimation, published a report saying that the police found that there was no evidence of any forged instrument. But there was no denial of the police investigation, no denial of the person being of importance to the investigation, and no denial that the house was searched. We learned recently here at Nation Watch that the young lady in question, Miss Cyrus, was summoned to a meeting at the region following the disclosures here on Nation Watch, the very next day, I believe it was. And she, recognizing what was happening, decided that she was going to resign, whereupon she was told by those in authority that she dared not. And even if she submitted a letter of resignation, it will not be accepted. She was part of the operation and could not abandon ship at this time. We discovered, flowing from last Sunday's report, some other interesting information. We discovered that there are Venezuelan nationals who have been given birth certificates, Guyana birth certificates, and who are believed not to be entitled to those Guyana birth certificates. Among others, in the villages, in the Mabaruma sub-regions particularly, have been included on a register for receipt of social assistance benefits. So here's another grand scheme for rigging by the People's Progressive Party. First, we started out with fake birth certificate allegations, and now we're at a place where persons who are able-bodied, capable of working, fit for work, are on a register to receive social assistance benefit. In fact, it has become so glaring that these able-bodied young people who are being bribed by the People's Progressive Party with taxpayers' dollars to which they are not entitled go to the Mabaruma post office to collect those benefits to which they're not entitled, and push away our senior citizens who are standing there for lengthy periods of time as they await their earned benefits from the system. So there's a massive rigging scheme on, ladies and gentlemen. And the People's Progressive Party believes that it can get away with these schemes in Guyana's hinterland without being noticed. And so in Region 9, there is the issue of alleged fake birth certificates. In Region 1, there's the issue of alleged fake birth certificates. In those regions, there are allegations of birth certificates being issued to persons who are not entitled to them. And now there's a grand scheme of bribing voters through social assistance vouchers to which they are not entitled. And on the issue of birth certificates, you know, everybody understands that there was a change in legislation that facilitates easy access to birth certificates. And many believe that the man in charge, the man who carries the title of General Registrar, I beg your pardon, is the man to fear. But there is the commissar behind him, a man named Visham Budu. And according to the Venezuelan national who spoke with me, Budu es el poder político. Con él, todo es posible. Budu is the political powerhouse at that registrar's office. And with him there, all things are possible. Guyanese, we need to be vigilant. And back to Mabaruma. In this whole scheme of social assistance, voter bribery, Sharon, you and I are friends. We've known each other for years. And I'm kind of upset whenever these conversations come up. I hear your name surfacing, and I'm deeply concerned. I'm wondering, are you involved? You're past retirement age, but you have this big job now. And you're part of this committee that deals with birth certificate issues. Are you involved? I hope not. I hope not. And Carlin, my dear, everybody in Mabaruma is talking about the castle you're building. And everybody is talking about a historical issue which caused you to run from Guyana to Venezuela. The issue of the sub-treasury in Mabaruma. Shall I say more? The regional administration reeks of corruption. You, Brenton Lashley, need to get your act together. And the REO, I always held you as a friend. But your actions in the region disappoint, for they suffer my people. Let's look at some issues of ingratitude before we get into our program proper with my guest, the esteemed gentleman from the Elections Commission. I want to show you ingratitude at the highest level. The use of state power to suppress, to oppress, to victimize, to destroy. Let's look at some of what happened yesterday.
You cannot take illegal instructions. You got all these police line up here, these men have better things to do. Come with illegal documents, we'll give you the vehicle. Go to the court and get, a court order. And I'm going to release the vehicles. I'll ensure that the vehicle releases in your custody. You can take my personal guns too. And these same personal guns, defending them in 1992, because I have guns since Apple time. I get guns since under Mr. Hoyt time. And these personal guns, defending them in 1992. I heard the Vice President said that talk about all these filthy things. I mean, in 1992, I never know Mr. Jagdev. I never knew him around, right? And in 1992, Freedom House had 4 guns when you had these problems, right? 2 was my own, 1 was Dr. Hanumanu, and 1 was Glenn Lalu. So I don't know, where all this nonsense coming from.
That's the first clip. And we hear some familiar names. Of course, Dr. Eula Hanneman is no longer with us in the land of the living, but the other name that was called we know. And we hope that there will be a newspaper publication speaking to this issue on the front page of that very popular Guyana newspaper. But let's look at the other clip, shall we?
But right now, Guyana, Barbados, ate it up Guyana, and they're telling me need. So for you to turn around and disrespect us, if not for the Prime Minister of Barbados, you wouldn't be in power today. Don't forget that the Prime Minister of Barbados came to Guyana, interfered into the election, ousted Granger, and that's how you, Barack Jagdeo, get back in power in Guyana. Let's not forget that.
Ladies and gentlemen, there's another clip that we may not be able to put our hands on immediately, but it's a clip of the younger gentleman, the son of the man who appeared in the first video, making a statement that he and his men protected the People's Progressive Party between 2015 and 2020. We know that in the mainstream media and in social media, we know that there's evidence, abundant evidence of, and most of us who live on the coast actually saw firsthand, Mr. Ali being transported in a 4-door black open back pickup truck owned by these people with the crest of the office of president attached to the front and rear of the vehicle. And so we know that when he says that he protected them, he wasn't in fact being dishonest. So here it is, a family that stood by the People's Progressive Party, protected them with men and guns, being destroyed through the employment of agents and agencies of the state in the full glare of the media. Ingratitude knows no bounds for the People's Progressive Party. You heard the gentleman from Barbados saying what he said about the Prime Minister of Barbados and the involvement, as he alleges in that clip, in the elections of Guyana. And yet, Mr. Jagdeo gets on a rant and cusses out Barbados as a destination of no consequence. Ladies and gentlemen, voters of the Cooperative Republic of Guyana, if people, as we say in Guyanese parlance, throw out the belly for you like that, and you throw all assets of the state at your disposal at them to destroy them, do you believe the People's Progressive Party will value your vote and give you the respect that you deserve as a citizen of this country were you to vote for them? If people stepped out of their zones of comfort to do all these things for Jagdeo and Ali, and then they, like the story in the song of Magadab, turn around and bite them, do you believe that if you vote for them, they will have your interest at heart, the welfare of your family at heart? Do you believe that they will care enough to preserve the assets of this country for future generations, your children, my children, our grandchildren, and generations yet unborn? I think not. But they see a sense of value in remaining in government, or else there'd be no allegations of fake birth certificates, no allegations of a voter procurement mechanism, which goes to the extent of sharing out cash grants legally and illegally and paying out social assistance to persons not entitled just to secure their votes. They know why they want to remain in government. You should understand why you should not entertain them in government after the elections that are soon to come. My guest is Mr. Vincent Alexander AA, Commissioner, Guyana Elections Commission. Mr. Alexander, I thank you for joining me on Nation Watch, and I thank you for your patience as I utilize some of your time. Welcome.
Thank you very much, Mervyn.
Recently, I believe it was on the 3rd, there was a ruling in a matter by the Chief Justice of this country, acting Chief Justice of this country. The matter was one where the Chief Scrutineer of the People's National Congress Reform approached the court for an interpretation of a provision of a recent amendment in 2022, treating with the replacement of verified residency with address claimed. The decision of the learned judge did not go in the applicant's favor. You wrote a very interesting letter that was carried in the press, and it is rather interesting that the issues you raise in this letter appear not to have been issues considered in the court. Was it a case where the attorneys did not venture in this particular area, or is it a case where representation was in fact made but not thought to be as important as you think it to be?
Mervyn, before I respond to your question, allow me to comment on your disclosures earlier on, with specific reference to Prime Minister Mayor Motley. When Prime Minister Motley visited Guyana in 1920,
No, 2020.
So 2020.
That's 100 years ago.
2020. Before the recount, herself and a team of CARICOM heads of government visited as a form of intervention into what was emerging. As chairman of the International Decade for the People of African Descent, we penned a letter to Prime Minister Motley. In this letter, we said that the problems in Guyana were deeper than merely electoral disputes. And if they were concerned about Guyana, then the intervention would be to look at the real underlying issues which might themselves lead to electoral issues. We wrote her that letter, asking for her intervention, asking for her attention. We did not have the courtesy of a reply from the Honorable Prime Minister. It was interesting to note, however, that when the first oil conference was held, and she came to be a keynote speaker, she found it necessary to refer to President Ali and Vice President Jack Dio as her brothers from a different mother. That's what she said. A conference that had to do with oil and gas. She found it necessary to identify with them not as fellow leaders, but as brothers, her brothers from a different mother. So I just thought I would make mention of that, since the Bajans themselves are now seeking to address the question of how she relates to Guyana and how Guyana relates to Barbados.
And catfish curry.
The question which you posed, which is slipping me a bit, having, as to whether the issues that I raised in my letter were raised by the lawyers, I'll answer it this way. There are issues which I raised in my letter which could not have gone unattended by the judge. For example, in Article 159, to which she makes reference, there are two aspects of that article which she obviously did not pay attention to. She quoted 159, and it's the main anchor of her case, her judgment, where it says no person shall vote as an elector unless he or she is registered as an elector. And I extrapolated, I think reasonably so, that she was also relying on Article 159(2), which says, subject to the provisions of paragraph 3 and 4, a person shall be qualified to be registered as an elector for elections if and shall not be so qualified unless on the qualifying date he or she is of the age of 18 years or upwards and either is a citizen of Guyana or, this is the one I want to note, satisfies such other qualifications as may be prescribed by or under any law. The point I'm making here is that she holds on to 159(1) and 159(2) in some regards, but does not note 159(2)(c), which says satisfy other qualifications as may be prescribed by or under any law. And the fact of the matter is that in the said constitution, the article which we misquoted on the last occasion, Article 73, I think it is.
Right. You
Article
had, you had
73.
said 173, but
Yeah,
yeah.
Article 73 very specifically says, members of a regional democratic council shall be elected by persons residing in the region and registered as electors for the purpose of Article 159. Let me say it again. Persons of a regional democratic council shall be elected by persons residing, not claiming an address, but residing in the region and registered as electors for the purpose of Article 159. So this is conjuncted with Article 159, which article requires a referendum to be changed, but points us clearly to Article 73 as a requirement satisfying other laws.
And being resident in the region
And being
speaks to the fact being established
Of
through some
residency.
method
The
of
question is,
government.
how do we determine
Right.
residency? You can't determine residency, as she claims, seems to want to claim, by simply giving an address.
Yeah, that's no verification.
Right. We know that prior to 2022, this question of residency was being determined by a visit to the place of residence to identify that the person actually resided there.
And may I add that if that visit found that person absent from the provided address, that registration process specific to that person was not completed. There were further visits that had to be scheduled.
Quite correct. If one sees the form that recorded such visits, you will see the form provided for visit 1, visit 2, visit 3, and provided for the signatures not only of the GCOM officials, but the scrutineers of the parties. So that we have in fact defined in our law prior to now, how this question of residency is determined. And therefore any issue of claim address and now bypassing the application of that form really flies in the face of what we understand in this country to be residency. in a circumstance where conjunctly 159 and 1 and 73 specifies in the case of the regions that they must be residency. And in our laws, there's similar specifications in relation to local government elections. The fact of the matter is that we have, I would say, five
Right.
elections.
Yeah. And
We
that's GCOM elections. That
GCOM, I'm
That-
GCOM,
yeah, that
not
doesn't
including the
include
Amerindian,
Amerindian, right.
the Amerindian elections. At the local government level, we have constituency elections where people are elected by a constituency to be a constituency councillor. At the level of the local government, we also have the PR elections where people are elected to be representatives of the entire local area. At the regional elections, we have people who are elected to represent the region. At the national level, we have people who are elected to represent constituencies in the parliament and people who are elected to represent the entirety of our population in the parliament. So those are 5 elections. And clearly out of those 5 elections, 4 of them speaks to a specific location other than the nation at large. And the issue that's before us is, should people be allowed to vote in those 4 elections without specifying or it being verified that they live within the area of concern? In other words, so somebody who does not live in a constituency merely give an address and be allowed to vote in that constituency. Should somebody who doesn't live in a local area, NDC for example, merely give an address and be allowed to vote in that NDC? Should somebody who doesn't live in a region merely give an address and be allowed to vote in that region? Somebody who doesn't live in a constituency, notwithstanding the technicalities of that election, be allowed to vote to influence who will be the electors in the constituency? My answer is no. My answer is no from 2 perspectives: the principles of the law and the logic, the contextual arrangements in our constitution, and the historical development of our system of constituencies. Having said that, to get back to your question, as I said earlier on, clearly not every provision was considered by the judge. And clearly provision 159, which she refers to, was not considered in its totality. But there are other provisions which may not have been referred to in the case that were not taken into consideration. But I dare say it is not beyond a judge, having listened to a case which is based on the Constitution and other laws, to do the research to determine the applicability, because law has to be interpreted in context as much as from a historical perspective. And you can't contextualize our law without looking at the other attendant articles or other attendant laws which are pertinent. And one should note that she did acknowledge that there are other attendant laws in her statement, that the law is all over the place.
I want to get to that. I have that here in my note. But before we get there, I want to read from what I consider to be a credible source of news source, April 3rd, 2025. And here news source is quoting the Chief Justice. In my view, the address claimed has to be accepted. This is the Chief Justice being quoted.
I heard her say that myself.
The registration officer cannot say to a person presenting themselves for registration that they do not accept the address they are given for whatever reason, and therefore disqualify the person for a forced registration or registration of a change of address. To do so would be to disenfranchise the person, which would be unconstitutional. End quote. From a personal perspective, I can't agree with this. I do not see a person not being able to prove that they have changed address and therefore not acting upon that claim of a change of address as a violation of that person's rights. I think that if you want to do something within the realm of the law, you need to have evidence. If you want to say you live here, you have to produce evidence that you live here. If you want to say that you're moving from here to there, even the utility companies, if you go to get a power supply from GPL or a water service connection from GWI, you have to prove that you live there. You have to give either a tenancy agreement, a power of attorney to show you have control over the place, or a transport to prove that you own it. And this is just a benefit from a service of the state. Here is where you're going to make decisions that will impact the lives of every citizen in the country, and where the laws say that you're required to establish. But it is rather strange, because I also read in a report that the Chief Justice said that, referring to our electoral laws, that they're all over the place, and that it, I suspect, meaning elections, is difficult to manage. And then goes on to say, and I'm paraphrasing here, goes on to say that there's work for the legislature. So if, on the one hand, you admit that the laws are all over the place, perhaps inferring that it's difficult or maybe not your task to piece it together, but referring that function to the legislature, then could we have a decision that says that?
Let me quickly respond to you. First of all, her statement about the law being all over the place and this need for legislative intervention could not be a reference other than that there is incongruency in the law. In other words, the law is conflictual. And I would agree with her that the law is conflictual, because the amendment, in fact, which removes residency and talks about a claim, is in conflict with our constitution and our legal architecture. Why do I say it's in conflict with our legal architecture? Our laws have to be interpreted contextually as much as they're interpreted literally. And if one sees what is the framework, the operational framework in Guyana, you would see, as you've correctly said, whether it's water, whether it's tin, all the documentation in this country requires proof of place, proof of address. Proof of address, something tying you to that place. I'm in a credit union, and one of the things we have to do when we're submitting the names of the management committee is proof of address, although the credit union is not geographic. So our legal framework really says that in all transactions,
We must find you.
we must be able to find you. And to find you, we have to not just be given a claimed address, we must have proof.
Even getting your child into school
Proof of address.
with respect to the
Yeah,
catchment
all of those
areas.
things. So here is a context
Yeah.
which this judge should be looking at our laws in, because these laws are not standalone. They're part of a legal architecture, a legal system. So that's the first and or second point I want to make. The other point I want to make is, for me, you need to understand that we have, I'm going back to this thing of 5 elections. Nothing in what is being asked for interferes with a Guyanese being registered wherever,
And allowed to vote.
voting for the National Assembly. Doesn't interfere with that. What it speaks to is the voting in relation to a specific constituency. So that every Ghanaian who is registered, as 159 says, will be allowed to vote. But tell me the logic of allowing somebody to vote in a place where the person does not belong, when in our legal architecture we see that our democratic system is built on the question of representativeness, it's built on the question of accountability, all of which can only be established if you have a known relationship between the electorate and the elected. And so when the registration officer goes to someone, or someone goes to the registration officer and says, here's my claimed address, and they can't prove that address, the registration officer is not denying someone the right to vote for two reasons. One, that person will have the right to vote in the national fifth level of the elections.
Yeah.
But what the registration officer is essentially doing is saying, look, in order to exercise your right, it has to be in the place where you belong. And so it's not a case of me denying you. It's a case of you not meeting the
enabling yourself.
requirement.
Not enabling yourself.
Not enabling yourself. And so this statement about taking somebody off the register and denying somebody is to see this thing from the flip side. The fact of the matter is the requirement really is to allow the person to exercise his entitlement by conditions. Condition being in this instance that the person must be able to show that they have that right by virtue of where they reside. Now, the judge's approach is very absolute on this right in 151.1. But you know our Constitution, again, if you look at it contextually, rights are never absolute.
Absolute, right.
Rights are never absolute. And we do have a situation in our laws where under the provision of, I think it's the fundamental rights or the human rights, it is specified that people have all of these rights, but that there is relativity, that those rights should not interfere with others being able to exercise their right. And I import that provision into this case for this reason. If someone is registered and allowed to vote where he or she does not belong and influences the outcome of those elections, that person is in fact negatively impacting the exercise of the right of the person who lives there. And so contextually our Constitution applies relativity to laws. So even if I didn't find all of these other supporting laws as have been found, the application of that principle alone, which affects our human rights, shows that a right is not absolute. A right is relative. And there seems to be a tremendous amount of absolutism in the way in which the judge has sought to apply 159.
It is apparent, if not clear, that the People's Progressive Party has a lot to defend when it comes to residency as it relates to elections. Why do I say that? The parliamentarian for Region 1 for the People's Progressive Party is Colin Crowell, who does not live in Region 1. The parliamentarian for Region 7 for the People's Progressive Party is Gail Teixeira. I don't know if she's ever been to the Mazruni district.
I would think she's been. Give her the benefit of that.
But she doesn't live there.
She doesn't live there, definitely.
How Priya Manik-Chan is the parliamentary representative for Region 3.
The girl from deep in Maikoni,
Yes,
living in Georgetown.
right. The question really for the voters who voted for the People's Progressive Party in those regions is, How on earth do these people or can these people represent your interest? They don't know that in the Mazaruni district, this sells for more than $500. This sells for more than $500 in the Upper Mazaruni. A bottle of water. The 12-ounce Coca-Cola is probably about $700. These people who represent the People's Progressive Party's voters in these regions do not live there, cannot relate to the issues, cannot represent the people adequately. And therefore, if this residency issue, as far as the voter is concerned, is probably verified in a court of law, it may by extension have to do with representatives coming from the respective geographic spaces where the electors exercise their franchise. And therefore, they have quite a bit to defend given the status quo. Mr. Alexander, I understand that the applicant, Carol Smith Joseph, has, through her attorney, signaled to the court their intention to appeal this decision. But you also said when you spoke a minute ago that in your view, the amendment of 2022 is not in conformity, my word, with the Constitution. My understanding is that any law, to the extent that it conflicts with the Constitution, is null and void. Is there any consideration being offered to a constitutional motion to knock down that amendment of 2022?
First of all, the case of Carol Joseph essentially addresses that question of the law being null and void because of its conflicts with what the Constitution provides for. As far as all of the provisions that I have been referring to, what the judge came up with is that it's not in conflict with. What Nandalal argued is that, in fact, that the change was intended to bring the law in line with the Constitution. Now, you make reference to a constitutional motion. You would have heard the judge say in no uncertain terms that this is a matter for the legislature. And so any motion here really is to seek to clarify what the Constitution intends and would be no different from the matter brought by Carol Joseph. So for all intents and purposes, in fact, in essence, this so-called constitutional motion has been brought and has been ruled upon in favor of the status quo, that is the amendment to the National Registration Act, which now provides for someone merely to claim an address. But let me get back to what you were saying earlier. In life, there's a factual aspect and there's a legal aspect, and sometimes the two are one and the same. The People's Progressive Party have obviously never shown our embrace of some elements of a normal democracy, particularly from the perspective of representation, because they have always had parliamentarians, and parliamentarians in particular, for the constituency element of the parliament that do not live in, do not come from the constituency. And you have quoted quite a few of the cases. That shows the disposition. That shows the disposition. And whilst the law may not have been very clear on that matter, it shows the disposition. It now shows that what they're seeking to do is to bring the law into conformity with their disposition. That's what this alter- this amendment to the law is all about, bringing the law into conformity with their actions. But you know, there's so much in our constitution that exposes what they're seeking to do. And here I want to make note of Article 78, Article 78B. It speaks specifically to electoral system. The electoral system in respect of local democratic organs, and this would be for the RDCs and the NDCs, shall provide for the involvement and representation of individuals, shall provide for the involvement and representation of individuals and voluntary groups, in addition to political parties.
These are contestants for offices.
Yes, yes. In addition to political parties, and accountability, keyword here, to the electors. Accountability to the electors. Who are the electors? Electors are the people who vote for them. Accountability means that you have to be able to respond, to give an account for what you do to the electors. How are you going to have a system where the electors are not from the local area and therefore are in no position to demand accountability? Our constitution goes, it's very clear what we're seeking to do. Accountability to the electors. Accountability is a relationship between people. And that relationship can only exist in a local area as specified here in the Constitution.
And is reciprocal.
If the people are from that area and are affected by the decision making and are represented by those who are elected. So our constitution clearly speaks to a system that should provide for people being known to be in a geographical area in relation to who their representatives are, in relation to where they vote, and in relation to their representatives, accounting to them for what goes on in that area. Because if you go to another article, you will see in the other article, and I want to go way back now to the principles in our Constitution, Chapter 2, Principles and Bases of the Political, Economic, and Social System, and to go to Article 13, which says, the principal objective of the political system of the state is to establish an inclusionary democracy by providing increasing opportunities for the participation of citizens and their organizations in the management and decision-making processes in the state. Citizens, with particular emphasis on those areas of decision-making that directly affect their well-being. So that here the Constitution is saying, what affects your well-being is the area where there should be decision-making and your involvement. Now that can only happen if you reside in the area where the decision is being made. It can't happen to have this emphasis on those areas of decision-making that directly affect their well-being. If they're not in the area, it doesn't affect your well-being.
And that process starts with registration.
And that process starts with registration. There's so much in our Constitution. If we were to contextualize the decisions based on the law at large, the whole law, you could never arrive at the conclusion that somebody could simply claim an address and be registered to go and vote where he or she does not belong, where decisions made doesn't affect he or she, where he or she cannot call for accountability. All of this comes through the Constitution.
I want to be devil's advocate here. Maduro, Mad Uru, has scheduled elections for Guyana Essequibo, as he styles it, our Essequibo, on the 25th of May 2025, for the election of a governor of the territory of Essequibo. The thousands, the tens of thousands of Venezuelans living in Guyana, many of them have no interest except survival. Some have political interests, some have military interests. If Maduro is to have his way, a governor will be elected to manage the affairs of our Essequibo. Because A, the Venezuelan parliament has ratified Essequibo as an inclusion, as an additional state of Venezuela. B, has appointed a general as interim governor. C, has approved a budget for the defense and development of Essequibo. How is this likely to affect what happens in Guyana in terms of how elections are conducted and what the outcomes are likely to yield?
I will answer you this way, Mervyn. First of all, I think I've heard that the contestants have been identified.
Any Guyanese?
I haven't heard of anybody who lives in the claimed area being identified to be a contestant. So it sounds like the PPP. Yeah? Mm-hmm. Secondly, I have this big question of where will these elections be conducted?
The actual places of poll.
Places of poll. And what is the register of voters that's going to be used for those elections? Are people who live somewhere in Venezuela going to claim an address and vote? And then we are told that the decision has been made because the majority of voters. So you see, when you do wicked things, they can come back to haunt you. Because people can do similarly wicked things and claim that it's right.
Because you say it is.
You said it's right.
Yeah. This is exactly where my thought was going.
We have got to be very, very careful with what we do in terms of observing the rule of law, because things we do may well come back to bite us, both internally and in relation to our neighbors and things and people other than those who are in Guyana. So that's how I see the PPP has put us and itself in a vortex by virtue of the way in which they are seeking to interpret our laws and to apply our laws, which may then be piggybacked upon by external forces in an attempt to do things like to take possession of our territory.
Governed by persons residing in another totally different and sovereign state.
And voted for by persons with a claimed address.
With a claimed address. Guyana is in total shambles here. There is this notice of intention to appeal. I believe the actual appeal may be premised on receipt of the written decision. Is a written decision out yet?
I do not know that a written decision has been made available to the attorneys in question, but I do know that one could hardly do a substantive appeal without the written decision, because it is based on the written decision that one has to articulate one's appeal.
Let's talk a little bit about GCOM, shall we? This matter before the court, has it engaged the commission at its meeting?
There were some discussions. There's nothing in depth or conclusive.
What is the disposition of commissioners at GCOM with regard to Attorney at Law, Mr. Da Silva's oral submission as it relates to the need for residency verification in some of the elections that GCOM has responsibility for?
Let me respond to that this way. Nobody has sought to argue against the substantive submission of Attorney at Law Kirk. What they've sought to do is to argue that he had no authority to make the submission, because according to them, that what he has submitted is not anything that was internally decided upon. The fact of the matter is that GCOM did not discuss the substantive matter and give instructions on the substantive matter. GCOM discussed the fact that he, Kirk, would represent us, and according to one of the commissioners, that he would make available to us his arguments, his written submissions, before they're actually submitted.
This is for review by the judge who heads GCOM?
This is for the commissioners to comment on. His written submissions, as far as I know, were circulated to us. I know of no comment that was made that would have altered his written submissions. I would go further to argue that his oral submissions were a projection, an expansion of his written submissions.
The chair of GCOM seems to want to be council chairman, determining authority and everything at the commission, from what I'm hearing. But I did, in fact, speak with counsel for Carol Smith Joseph, Dr. Todd, who said that what Mr. Court Da Silva, Attorney at Law, said that resulted in that statement being issued by the CEO of GCOM should not have come as a surprise, could not have been a surprise, because, as you just pointed out, whatever was said in open court was on record in documented form through written submissions.
Let me clarify that a wee bit. There were written submissions which we had knowledge of. The court then, based on the intervention of the attorneys, provided for additional oral submissions. The oral submissions would not be a repeat of what's in the written submission. It would be an extension of the argument. So other things could have been mentioned that were not necessary, but it would not have conflicted.
Nor would it be new.
Would not have conflicted with the written submissions. One could see a logical development of the oral in relation to the written.
Where are we, Ms. Alexander, as far as elections 2020?
Just let me go a little further. For
Sure.
example, in the written submissions, GCOM did not say that we have to comply. GCOM did not say that somebody should not be um, able to simply rely on a claimed address. What GCOM said is if there's a problem with somebody who submits a claimed address, then the system of claims and objections can be used to prove the person doesn't live there.
And then what?
And then that would be a claim and objection.
Yeah, but when you prove that, what?
Then the person would not be in the list.
Isn't that removing a person from the list?
Yes, yes. But the law provides for removal under those circumstances. And so what GCOM was saying is that claims and objections could be used to pursue the objective of the applicant rather than for GCOM to take it onto itself to go and verify addresses.
But is that not an admission that?
Well, we have a
Residency.
provision. We have a provision.
Yeah, of course you do.
But it is an admission. That's why I'm saying that the oral submissions did not clash with the written submission. Because the written submission spoke to the persons being taken off through a claims and objections process.
Well, why then would GCOM seek to argue against something that it accepts as a normal course of its operation?
GCOM, in essence, didn't argue against it. GCOM, in essence, provided a methodology for achieving what was being asked for, other than the methodology proposed by the applicant.
All right, let's shift a little bit to preparedness elections 2025. Where are we with that? It appears to me as though not much is being said in the public space regarding GCOM's readiness for elections. I have not, for example, heard GCOM saying elections are constitutionally due by November 2nd latest, and we will be ready to have or to hold or to manage or to conduct elections by a certain date.
Let me answer that question this way. We have recently received the plan for elections. And if my reading of the plan is correct, in that plan, GCOM suggests that they will be ready for elections as early as September.
Yeah, well,
And that's what the plan suggests.
well,
Now,
that is to be
elections-
anticipated because toll-free bridges were announced 1st of September and a number of other things. So it's anticipatory, really. GCOM seems to be working with the People's Progressive Party.
I will read. It is obvious that there is collusion. It is obvious. The way in which the commissioners seek to impose their views on the administration and the way in which the administration is condescending does suggest this collusion.
Biometrics. Where is the conversation at the level of the commission with respect to biometrics? And I know that the chairman had, independently of the commissioners, publicly said that it is possible, but would not be possible in time for elections 2025. I gather from what I've been reading and hearing that pronouncement came not from the commission, but from the chair.
The chair is the judge, isn't she? There are commissioners who are advocates of biometrics. There are commissioners who are antagonists of biometrics. And it's a 3-3 split, so it leaves it to the chair. So in a sense, what the chair says becomes the decision of GCOM. To be very frank, the question of biometrics is not presently being discussed in GCOM. It is not something that may not come up for further discussion, but it's not presently being discussed. And the fact of the matter is that in recent times, due to postponements, cancellation of meetings, a number of critical things haven't been discussed. So we are still to finalize the discussion of removal of the dead from the list. That has not been finalized. We still to finalize the discussion on the question of the Commonwealth citizens and them voting in our elections. That is still to be finalized. I have placed on the agenda the question of the incarcerated being allowed to vote. It hasn't happened in the recent past. That is still to be finalized. So there are a number of critical issues to be finalized. We did not meet last Thursday as was intended. The chairperson canceled the meeting because she said she was in no position to contribute to an essential agenda item for the want of information that the Secretariat has to make available. And my response to her was, in writing, that there's so many matters to be discussed. How can we cancel a meeting for one agenda item?
Would it be reasonable to conclude from what you've just said that GCOM is really not ready for elections 2025?
I wouldn't
As
say,
we speak.
I wouldn't say that GCOM is not ready for elections 25, but I would say GCOM is not ready for a free and fair election 2025. They're two different things.
Yeah. I
GCOM
concede.
is proceeding in a manner that does not address certain issues, but you can call a formal election. Whether that will be free and fair is another matter.
With the possibility of the earliest possible time for election being September, let's just hazard a guess for conversation, mid-September.
Let me say this to you, that the earliest time in that plan
It's July,
is
no?
September. However, in a meeting with the European Union, when that question was posed to the CEO, he said two things. He referred to the September, but he also said that it is a function of the president to call the date. And so, in a sense, he was saying, look, my plan says September, but it's not for me to determine. The president calls the date. Now, there's a conflict there because while the president has the right to call the date,
He has to be given parameters.
there are also statutory things that's got to be done. It can only be done by a certain time. And so it would be out of sync for a president not to inquire of GCOM on its state of readiness before calling the date. But he left it open. The president is the one to call the date. So you can see where he's going.
Subservient. For the purposes of this conversation, let's just make an assumption that it's mid-September is a possible time. Between now and then, were minds to be changed? Do we have sufficient time to get biometrics up and running? And secondly, have those electronic devices to be used in such a process been procured by GCOM?
No, they have not been procured. And my initial discussion with the technical people was that we should have started to implement the system for biometrics in January if we were to be up to speed. So we are behind hand in terms of the technical people saying what time is required. So that the question of biometrics relies now on a different issue. Will there be some extension of the time?
So it comes down to political will as opposed to
Definitely.
tech. Yeah. What is your own anticipation? Vincent Alexander's anticipation.
I try these days not to be guided by anticipation. I try to be guided by an objective and a continuous struggle for the achievement of the objective.
Mr. Alexander, I'd like to thank you very much for taking time out and joining me on Nation Watch today. Ladies and gentlemen, you've benefited once again from the expert on this particular issue. biometrics are in jeopardy. Free and fair elections are not a certainty. Time is getting short and things are not looking good. In the meantime, in the meantime, we've seen state resources, state personnel, state agencies employed against private citizens. Glaringly so in this particular instance, where the matter at hand is before the court. And we're going to show you how state institution and personnel are used against private citizens. These are borrowed bits of footage from social media. And while this is happening, the residents, the citizens of this country, the owners of land on the frontier with Venezuela are fearful for their lives, are not being visited by the authorities, are not being comforted by government, are not being spoken to by president, are not given any assurance that their welfare, well-being, and personal and family security are taken care of on the frontier. Nobody is going out there in a show of force against hostile neighbor to the west. They have brought military assets into our territory in the eastern half of Ancoca, Guyana's territory. They've constructed a bridge. They've brought over assets. Footage on social media showed persons in military uniform in small boats traversing Guyana's waters, believed to be Venezuelan nationals, believed to be Venezuelan military. But there is no reciprocal response from the Guyana Defense Force, from the Guyana Police Force. But the Guyana Police Force is being sent out, is being deployed to confront private citizens over matters that are already before the courts in this country. Imagine the fence you're seeing in this video is the border between Guyana and Venezuela. Just imagine that for a second. This is where our assets are being deployed. This is where our assets are being deployed.
Okay, well, I'm not aware of that, sir, but what
The
we
GRA, full force.
present the vehicles to the revenue authority.
Yeah, he will decline that invitation.
Okay, noted, no problem. Thank you. Thank you.
Bye-bye.
Officers, please don't take political directives.
Fully held siege in their home.
They came again and the lawyer told them the matter is before the court.
Right.
Yes.
For next week?
Thank you.
Yes.
Thank you for that. The police and the customs, Guyana Revenue Authority, deployed a man, his family, under siege in their homes in a matter that is before the court. And Guyanese on the frontier feel unsafe, and no police, and no military support, and no government assurance is there for them. I salute my indigenous sisters and brothers who live on the frontier. I salute all Guyanese who live on the frontier. And I say to you, continue to hold your resolve. Continue to stand firm as we defend our territory. Ladies and gentlemen, that's all we have for today on Nation Watch. That's all the time we have. Until we meet again, God bless.